Divorce by wife under Muslim law. A strong bond between a husband and wife is necessary for a happy family. In Islamic law, marriage is a contract between the parties, but in some cases, the husband and wife faces a lots of difficulties in performing their matrimonial ties, which leads to divorce between them. In Islamic law, divorce is considered as an evil, but in some cases, this evil is considered as a necessity because when it is impossible for the parties to the marriage to maintain the relationship with mutual love and affection, then Islam permits them to get separated and live apart. A divorce may be by the act of either husband or wife. In Islamic law, the basis for divorce is the inability of spouses to live together. If the spouses are not happy together, then it is better for them to live separately and independently rather than to compel them to live together in an atmosphere of hatred and anger. Divorce by wife. According to Prophet Muhammad, if a woman is prejudiced by marriage, let it be broken off. It is of essence in Islamic law that women are given proper opportunity to divorce their husbands if they are not able to perform their marital ties. Generally, there are two ways in which a woman can divorce her husband. First, through a mutual agreement between a husband and a wife, that is khula and mubarak. Secondly, through a judicial decree by filing a suit against the husband in court of law, that is under the Dissolution of Marriage Act 1939. Muslim law provides for various kinds of divorce that Muslim women can give to Muslim men. Khula. Khula means literally to take off clothes and hence to lay one's authority over a wife. Under Muslim law, a marriage can be terminated either at the will of husband or of wife or by a mutual agreement by the two. If the marriage is dissolved at the request of husband, then it is known as talaq. Similarly, the wife can also divorce her husband if she is satisfied that two of them are not able to perform their matrimonial ties. The Muslim woman can release herself from the marital tie by giving up some property in consideration for which the husband is to give her a khula, and when they have done this, talaq ul bain will take place. Valid conditions of khula. There must be a common consent of both husband and wife. Some iwad must be given by the husband, by wife to her husband. For khula to take place, it is necessary that some iwad, return consideration, should be given by the wife to her husband. Under khula, a marriage can be dissolved by an agreement between the husband and a wife for a consideration paid or to be paid by wife to her husband. Such an agreement, if the wife alone is desirous, is called khula, and if both husband and wife are desirous, is called mubarak. When the husband and wife are not able to live happily together and are apprehensive that they cannot observe the bonds prescribed by the divine laws, then a right is confirmed to the wife to get her release from the marital ties. The concept of consideration is necessary precondition for the validity of khula. Since the wife is interested to break her marital tie and leave her husband, then she must pay a consideration to her husband as compensation, and she can also forgive full or part of her dower money. However, if the consideration is not paid to the husband by his wife, then he cannot be compelled to comply with the agreements of khula, and he can ask for restitution of conjugal rights. Khula is a conditional divorce in which the wife is at liberty to purchase her freedom from her husband if she comes to the conclusion that it is not possible for them to live as a husband and wife. Khula is as the instance of wife in which she agrees to pay a consideration in return of which her husband would release her from the marital ties. Lian. Under Muslim law, a woman is guaranteed a right to divorce her husband if he falsely and baselessly charges her with adultery, and this doctrine is known as lian. The Quran and Hadith both guarantee a divorce to a Muslim wife if her husband is imputing a false unchastity to her character. If a man is charging his wife with adultery, then he must prove the allegations made by him. And if he is not able to prove it, then the wife has a right to divorce him under the doctrine of lian. The objective behind this doctrine is to punish the husband for falsely alleging the charge of adultery upon his wife. In India, a Muslim wife can also bring a suit for defamation against her husband as a ground for false charge of adultery. In Zaid Hussain versus Ummatur Rahman, it was held that a Muslim wife is entitled to bring a suit for divorce against her husband and can obtain a decree on the ground that the latter falsely charged her with adultery. In Rahima Bibi case, it was held that a Muslim wife can sue her husband for divorce on the ground that he had falsely charged her with adultery. Under the doctrine of lian, mere charge levied by the husband will not automatically dissolve the marriage. A dissolution decree by court of law is essential to put an end to the marital ties. The charge of adultery by a husband against his wife can only be established by a direct testimony of the four witnesses from the nature of offense. However, the case in which clear and direct evidence is present is extremely rare. Talaq-e-tafweez. It is also known as delegated divorce. The delegation of power to dissolve is technically called tafweez. Tafweez means to say make someone the owner of an act which appertains to the person making the tafweez. Talaq-e-tafweez is one of the most important form of divorce under Muslim law because it gives Muslim women a right to divorce their husband without going to court of law. In this form of divorce, a Muslim male can delegate his power of repudiation of marriage to a third person or to his wife also. He can delegate his own right of pronouncing divorce to his wife. It is a delegation by the husband of the power of talaq to the wife, designing her to give the effective sentence. Tafweez is of three kinds. Ikhtiyar, that is by choice. It means by giving her the authority to talaq herself. Amr biya, it means leaving the matter in her own hands. Mashiyat, pleasure. It means giving her the option to do what she likes. Under Muslim law, a husband and wife can enter into an agreement at the time of marriage that this shall be the duty of husband to maintain his wife, and if he is not able to fulfill his promise, then the wife is at liberty to dissolve the marriage. Under certain conditions, a wife can pronounce divorce upon her, provided first that the option is not absolute, and secondly that the conditions are necessary and are not opposed to public policy. A delegated divorce can be given by the person who has attained the age of majority and of sound mind. In delegated divorce, the age of majority is determined by Muslim law and not by Section 3 of the Majority Act. In delegated divorce, the husband can delegate his power of divorce to any other person, including his wife also. The husband possesses the power to appoint another person as his wakil. He can also appoint a third person to divorce his wife on his behalf. But the husband still possesses the power to divorce his wife even after he delegated his power to any other person. In Hamidullah versus Faizun Isa, it was held that under Muslim law, a husband may give to his wife the power to divorce herself from him according to the form prescribed by that law for divorce by the husband. Dissolution of Marriage Act 1939. In 1939, an act was passed to secure the rights of Muslim women. The Dissolution of Muslim Marriage Act 1939 was passed to provide various grounds to enable Muslim women to divorce her husband. Women generally face many difficulties in their matrimonial relations for which they have no remedy. To solve these problems, the Act of 1939 enabled the Muslim woman to divorce their husband. Section 2 of the said Act states that a woman married under Muslim law shall be entitled to obtain a decree of dissolution of her marriage on any one or more of the grounds mentioned in the Act. This Act states that it is lawful for a Muslim wife to dissolve her marriage on any of the recognized grounds in this Act. But if the wife cannot dissolve the marriage herself, she has to obtain a decree from the court of law, and the marriage can be dissolved only if the court has passed the dissolution decree. Various grounds on which a Muslim wife can claim dissolution of her marriage are: whereabouts of husbands are not known. A Muslim married woman under Muslim law is entitled to obtain a decree of dissolution of her marriage if the whereabouts of her husband is not known for a period of 4 years. However, it is of essence that the lady will not marry for the next 6 months after the decree is passed. The reason for this is that if her husband appears within 6 months and is willing to perform his marital obligations, then the court is satisfied, then the decree may be set aside by the court. Failure to maintain wife or negligence on part of husband. A woman married under Muslim law is entitled to obtain a decree of dissolution of her marriage if her husband has neglected her or has failed to provide her maintenance for a period of 2 years. Under Muslim law, it is essential that the husband is duty bound to maintain his wife, and if he fails to maintain her, then the wife can sue him for divorce. Imprisonment of a husband. A woman married under Muslim law is entitled to obtain a decree for dissolution of marriage if her husband has been sentenced to imprisonment for duration of 7 years or upwards. Failure to perform marital obligations. A woman married under Muslim law is entitled to obtain a decree for dissolution of her marriage if her husband has failed to perform his marital obligations for a period of 3 years, but it is of the essence that he may have failed to perform his marital obligations without a reasonable clause. Impotency. A woman married under Muslim law is entitled to obtain a decree for dissolution of her marriage if her husband has been impotent at the time of marriage and continues to be so. In this case, the burden of proof is upon the husband to prove that he is not impotent. The husband can satisfy the court within a period of 1 year that he is no longer impotent. If the court is satisfied, then it can set aside the dissolution decree. Insanity, leprosy, and venereal disease. A woman married under Muslim law is entitled to obtain a decree for dissolution of her marriage if her husband has been insane for 2 or more years, or has a leprosy which may be curable or incurable, or has a venereal disease which may be curable or incurable, and may be of any duration. Operation of puberty. A woman married under Muslim law is entitled to obtain a decree for dissolution of her marriage if she has been married before she attained the age of 15 years by her father or any other legal guardian. Cruelty. A woman married under Muslim law is entitled to obtain a decree for dissolution of her marriage if her husband treats her with cruelty. Cruelty has been ground for divorce even before this act. A Muslim is always given the right to divorce her husband if she has been mated with cruelty. Conclusion. In this patriarchal society where women are considered inferior to man, where a man has every right and remedy, but woman has very little to cherish for her. Women are not given their basic rights to live their lives. In India, talaq is a mere arbitrary act of husband who may repudiate his wife at his own pleasure. Man can divorce their spouses easily, whereas a woman faces a lot of legal, financial, and patriarchal hurdles to divorce their husband. Women face a lot of criticism of this patriarchal system if they want to give divorce to their husband. However, this trend is changing now, and women are also provided with equal rights to divorce their husband. Under Muslim law, women are given rights to divorce their husband if he is not able to support her life. Muslim law provides for various kinds of divorce that a wife can give to her husband. That is khula, liyan, talaq, tafweez, dissolution of marriage. Women can also divorce their husband if she is satisfied that they are not happy together and cannot perform their matrimonial ties. Women are now standing on an equal footing with men.